Her uncle gave her a discount apartment, then took her to court. A family dinner turned into a court date, and by the time it was over, nobody was walking away clean. The landlord and the tenant had known each other for 32 years. That's how long the tenant had been alive. She was his niece, and when she'd moved back to the city after a difficult divorce, her uncle had offered her the basement apartment in his duplex on Clearwater Street at $600 a month, roughly half the market rate. He called it family. She called it a lifeline. For the first 8 months, by most accounts, the arrangement worked. The niece paid on time. The uncle handled repairs without complaint. They shared holidays, exchanged keys, and operated with the kind of informal trust that only exists between people who think they'll never need a contract to protect themselves from each other. There was no formal lease. That detail would matter enormously later. The trouble began on a Thursday evening in mid-February when the uncle, who lived in the unit directly above, filed a noise complaint with the city. According to the report, his tenant, his niece, had been playing music past 11 p.m. on multiple occasions and had recently begun hosting what he described as disruptive gatherings on weeknights. He claimed his sleep had been affected, his work performance had suffered, and that he had verbally warned her 3 times without result. He served her a notice to vacate within 30 days. She didn't leave, so he sued her for $200, representing 2 months of what he claimed was lost rental income during the time it would take to find a new tenant, plus damages for emotional distress caused by repeated lease violations. Never mind that there was no lease. His attorney argued that an implied rental agreement still carried enforceable obligations. In court, the uncle testified with quiet authority. He described a pattern of escalating behavior, the bass from her speakers bleeding through the floorboards, the laughter of strangers at 2 in the morning after debris he claimed to find in the shared entryway. He presented a log he said he'd kept on his phone, 17 entries over 6 weeks, each with a timestamp and a brief description. He seemed organized, credible, like a man who had done everything right and still ended up wronged. Then the niece took the stand. She was composed in a way that surprised the courtroom. She didn't deny the gatherings. What she said was this: her uncle had attended 2 of them. He had sat at her kitchen table, eaten her food, and stayed until nearly midnight on both occasions. She had text messages. She showed them to the judge. Casual, warm exchanges where he'd ask what time people were arriving, whether he should bring wine. She also submitted a series of messages from the weeks before the complaint was filed. Messages in which her uncle had asked 3 times whether she would consider moving out so he could rent the unit to a colleague's son at market rate. She had declined each time, but the moment the case truly shifted came from an unexpected direction. The city's noise complaint division confirmed that the complaint filed by the uncle had triggered an inspection of the property. During that inspection, the basement unit was found to have a non-functioning smoke detector, an exposed electrical panel that violated city code, and inadequate window egress, meaning that in the event of a fire, the tenant would have had significant difficulty escaping. The city had cited the landlord, not the tenant. The uncle had known about the electrical issue for at least 4 months. The niece had texted him about it in October. His response, entered into evidence, read, "I'll get to it." The judge ruled in favor of the defendant. The $200 claim was dismissed entirely. The court found no enforceable lease, no documented lease violations under the implied agreement standard, and significant evidence that the eviction notice had been retaliatory in nature. The uncle was ordered to remediate all code violations within 60 days at his own expense or face daily municipal fines. He was also ordered to pay the niece's $800 in court filing fees. She moved out 2 months later anyway, not because she had to, but because, as she told a mutual cousin afterward, she couldn't imagine falling asleep beneath his floorboards anymore. The uncle completed the repairs. The colleague's son moved in at 1,000 bancunams a month. The family hasn't shared a holiday meal since. The case was filed, the case was dismissed, and somewhere in between, a relationship that had survived a divorce, a cross-country move, and 32 years of shared history didn't survive a noise complaint and a rent increase that was never actually asked for out loud. Here's what this case leaves you with. If someone offers you a favor, they later expect to take back. Was it ever really a favor or just leverage they hadn't used yet?